Well, greetings, friends. It's Danielle Smith. Welcome to this very special edition of the Danielle Smith Show, which we'll be doing over the course of the next number of weeks. As you know, anytime I am interested in getting an update on an important issue, I talk to the very best expert. And I figure since I'm talking to these folks anyway, why don't I share that with you so that we can both learn together? Today, I'm so delighted to be talking with Brian Peckford. You will know him as the former Newfoundland and Labrador Premier. He was there from 1979 to 1989, 10 years. And you'll also note that within that time period, something very, very important happened in our political history. We signed into the Canadian Charter of Rights and Freedoms, and we repatriated our Constitution. And Mr. Peckford is our last living signatory to that Charter of Rights and Freedoms. He's been fighting a huge battle with the federal government against vaccine mandates, travel mobility, Section 6 of the Charter of Rights and Freedoms. I think he got a victory this week, but I'm interested in hearing how he sees the climb down on the issue of the vaccine mandates and restrictions. And he joins me now to talk about it. Mr. Peckford, thank you so much for being with me today.
Thank you. I'm pleased to be here. Anytime I can talk about the Charter of Rights and Freedoms and what's happening in our country, I'm all here.
Fantastic. I'm glad to hear that. So let's talk about what I heard and thought I read this week. I read that the term they're using is suspending the requirement for that only fully vaccinated travelers are allowed to travel. They also talked about suspending the requirement for rapid tests. And I know that you're a stickler for words. I guess what worries me about that language is it sounds temporary to me. And I'm always worried about what might happen when we get into the next fall respiratory virus season or we get into a new variant. I'm just wondering if you share some of those same concerns.
Absolutely. I mean, the first thing that my lawyers and I coggered onto when the pending announcement was coming was the fact that they had seen in some of the early reports that it was going to be a suspension rather than a cancellation. And right away, the flags go up because this is not an acknowledgement of anything. This is a very grudging kind of thing by the federal government, and they're holding in their power the right to reimpose these unconstitutional, non-scientific vaccine mandates as it relates to travel. And so you're dead right. One has to be suspicious given the way in which they did that. The other thing one has to be suspicious about is that it doesn't cover everything, right? If I leave the country now, I'm unvaccinated. If I leave the country, fine, I can leave. But when I come back in again, I'm going to have to be tested and I'm going to have to be quarantined. So that's only a partial suspension of their mandate. So that's the way it should be described, a partial suspension of the vaccine mandate as it relates to travel. And by the way, they did bring a bunch of workers and stuff back to work, federal workers who are unvaccinated. But one of the most important part of our economy, the truckers, they still have the mandate applying to them.
You're kidding.
I mean, does anybody think that this is done because the truckers were brave enough to drive to Ottawa and oppose the unconstitutional measures in a completely civil disobedience way, in a completely civil way? So obviously the federal government wants to make the truckers be an example and are vindictive about that group of people in our society. They're still being discriminated against. So this whole so-called lifting of the travel mandate is just that, a pretty weak and misrepresenting what's really happening, because it doesn't apply to everybody, it doesn't apply to everything, and meanwhile it's only temporary in any case.
Oh, it's unbelievable. Can I ask the other thing that I found interesting in the announcement is you have Dr. Theresa Tam now suggesting that 2 shots do not fully protect against the Omicron variant and people should get 3. Now, it always worries me when I hear this kind of language because they have such incredible power to dictate. So if we've got only a suspension of these rules, it doesn't apply to everyone. Unvaccinated Canadians still have to be tested on the way back in. Are they signaling that at some point they're going to make it mandatory to have 3 in order for Canadians to have full and free travel mobility in the country? Or am I reading too much into it?
No, you're not, because I think it's already happening. I've just been told yesterday that they're going to introduce, now the provinces would have to do likewise, but the federal government is going to introduce and make mandatory that you must have 3 shots in order to be fully vaccinated. So I think that's now a fait accompli. And so your suspicions, looks like, were quite valid, and that this is going to be brought in by the federal government. Now we'll have to wait and see what the various provinces will do, because as you know, health is a provincial jurisdiction, and therefore in order for the mandates to apply to everybody across the country, all these provinces would have to bring in the definition of fully vaccinated is 3 rather than 2. But apparently the federal government is moving ahead to do that now.
Well, so what are the implications of that? I was trying to have the conversation with somebody, said, well, I think they're actually making it 3. And their answer was, well, what does it matter if the restrictions are removed? Is it really just advisory? And I'm trying to figure out where the province has the ability to forge ahead on different policy from the federal government. I guess I'd be worried that if they confirm that it's 3 and we don't, does it then mean that anyone who doesn't have a 3rd dose in Alberta is not allowed to get on a plane?
Only those, no. Yes, it would. Yes, it would. As it relates to travel, interprovincial travel or international travel, because that's federal. And so therefore you would be under that new 3 thing, because what they're saying is under so-called removing the mandate, they're talking about vaccinated versus unvaccinated, and now vaccinated would be 3 rather than 2. So built into there.
I'm trying to understand, like, I thought we had a constitution for a reason. I thought we had a division of powers for a reason. It does seem that if we do have health that is exclusive jurisdiction of the province, how can the federal government come through with essentially, it isn't really a choice if they say you have the choice to do whatever it is you want, but look at these massive, massive consequences. I mean, our economy cannot survive having people locked down from being able to travel in both of our major cities. So tell me how you would interpret what the Constitution was supposed to mean.
No, but I think what we have to be clear on is that when it comes to interprovincial and international travel, that is federal under the Constitution. So they can quite likely get away with it there constitutionally. But all the other people in the provinces, so it's only under federal jurisdiction that they could do it. So in order for the 3 jab thing to apply to people who work for the provincial governments or in the provinces and not under federal jurisdiction, then the provinces would have to make that change. There's no question. They would have to make that change. But far more important is, you may have missed it, and none of the mainstream media are carrying it. My lawyers in court have successfully gotten the federal top epidemiologists to say under oath that they did not advise the federal government to bring in the travel vaccine mandates because they scientifically don't work. We have that on the public record. Keith Wilson, my lead lawyer, was on with Ezra Levant yesterday doing the interview explaining that. And of course, the mainstream media are not carrying it. But this is a bombshell. This is a bombshell in the court of law, the Federal Court of Canada. The top epidemiologist in the Public Health Agency of Canada has under oath testified that she did not advise the federal government to bring in vaccine travel mandates.
Well, then where did it come from then? If it's not health policy guiding this, where did it come from?
Exactly. It's a political decision. As obviously, it's not a health science decision, like we've been saying all along. And to add insult to injury, or to make this thing even more valid, under oath also, my lawyers were successful in having the top policy guy in the Department of Transport, under whose aegis the travel mandates came through the Aeronautics Act, testify to the same thing that the top epidemiologists said, that they did not recommend going ahead with these travel mandates.
Talk to me a little then, since you're obviously putting testimony forward and dealing with health issues. and dealing with health policy, because that always seemed to me is that it's a trump card, is that if you can make the health case and you're doing it for health reasons and to protect the broader population, that seems to be unquestioned by the court. But it's quite fascinating if you remove that as the purported excuse for these rules, what's left standing? What is the argument that they're able to make now?
That's why I'm saying it's a bombshell, because what is left for the judge to rule on? The only issue, it seems to me, is like what happened in Manitoba, in the Manitoba court, where the Manitoba court twice ruled for the government, and it came down to, and this is very sad, that the judge believed what the government said and didn't believe what the independent experts said. So it comes down, and they don't have a right to do that. They've got to determine whether in fact this is factual or not, that this can stand under scrutiny, and the judge should have brought other people in so he could better understand the research that it was being done. And by the way, this judge made that decision and completely ignored Dr. Douglas Allen's study of 80, report of 80 studies around the world back in April 2021, and the judge's decision was in October 2021. Okay, May, June, July, August, September, October. 6 months later, the judge makes a ruling ignoring the data, which has never been debated, about what Douglas Allen said, who's a Canadian at a Canadian university producing this wonderful report. And so what we have here is the judiciary taking on expertise for which they have none.
Tell me if this is how the Constitution was supposed to be interpreted, because
No,
but you were at the table, so you know what you were talking about at the time. But it seems this extraordinary deference to almost like, I mean, initially, I guess there was this pretense that there was a solid health recommendation for why we were doing this. Now, could it really come down to is, well, we don't really know, but we're just going to defer to the federal government to trample over the charter? Could that potentially happen?
That's the only refuge now, to me, that the federal government has left in the case that that I am taking with my lawyers in the federal court right now, because those two testimonies, both by the top epidemiologist and by the top policy person from the very department through which the travel mandate is initiated, are saying they did not recommend it. Then where did the data come from? Where did the recommendation come from to move ahead with these travel mandates?
I'm trying to remember the sequence of events, because I don't know if we were one of the first to bring in the travel mandates or one of the last. Were we saying monkey see, monkey do, following one of the other jurisdictions?
I think it was last October. So I think we're following others more than anything else. Yeah.
So tell us a little more then about what is the precise point of law that you're trying to determine in this case?
Well, we're trying to, number one, there's two points of law, if you will, to make it really, really simple. The travel mandate was had to be brought in under some piece of legislation, and that piece of legislation was the Aeronautics Act, which is under the Department of Transport federally. Okay, so it's the Aeronautics Act. So we are arguing, my lawyers are arguing in court, number one, that the Aeronautics Act does not apply in this case as it relates to travel. The Aeronautics Act applies to the safety of the plane, the safety of the transport vehicle, of the vehicle that's used for travel, right? And in this case, as it relates to airplanes, Aeronautics Act, it's, in other words, my lawyers are arguing it's ultra vires. It does not apply. It does not apply in this case. And so this is a wrong application of the law, and therefore it should be thrown out. Secondly, we argue that it violates the Charter of Rights and Freedoms, Section 6, mobility, which says every Canadian has the right to move and travel anywhere in this country or leave this country. So it's both a challenge against the act under which the travel mate was implemented, and it's an argument against breaking the Charter of Rights and Freedoms.
Let me go to the first one, because I'll try to stretch the argument to the breaking point, because I'm sure that's what the federal lawyers are trying to do. But could they argue that to keep a passenger safe, you have to make sure that there isn't a higher risk of having infected passengers on the plane. Therefore, that falls under the safety rules. Could
Well,
you
that
also argue that to keep the staff safe, that they're constantly being exposed to new passengers, that you want to try to find a way to limit their exposure as well? Could that be the safety argument that they're making to justify bringing it under the Aeronautics Act? Does that fly?
up until 2 days ago, they may have had an argument, although we have health experts that have already testified in the court and have been cross-examined, and our data is there showing that this, in fact, from a health scientific point of view, does not help safety, does not help the health of the people involved. Number two, now, as of today, the epidemiologists and the top policy people in Transport Canada are saying we did not recommend it. In other words, that whole safety and health argument for the people involved in the travel industry falls because there's no justification for bringing it in from a scientific point of view, at least from a scientific point of view as it relates to the top epidemiologist and as it relates to the top transport policy person. And where else would they get their recommendations if not from those two individuals? And under oath, they have said they didn't recommend it because the science doesn't justify them bringing it in. So therefore, that argument now falls completely on its face.
I feel like you need to educate us a little bit on what the science actually says, because so many things have been invoked in the name of science that it's hard to figure out what is real science and what is just political spin. Why? Because it sounds plausible. I'll give the government this. It sounds plausible that if you limit the number of people who can go on a plane by those who are vaccinated versus those who are unvaccinated, it seems plausible that you would reduce the number of people who are infected. But why is that not good science? What is it? What have we learned in the meantime?
Well, all of the science that has been done on this, all of the studies, Paul Alexander's putting them out almost every day, and others, that there is not sufficient, if you will, a problem here to endanger the health of the traveler, and that people around the world right now, where they don't have these travel mandates for the last several months. Millions of people have been traveling, and the level of infection amongst those millions of people that have been traveling has not been any greater than in the general population. So therefore, where's your argument, right? Now, on top of that, that's sort of like anecdotal information, but which is very powerful given these millions are traveling around the world every day and therefore are not getting infected any more than anybody else. But the actual studies that have been done, that have been exposed by Dr. Paul Alexander and others around the world, demonstrate that there is no science that can sustain a mandate on travel.
I feel like there is also more information. I'm wondering if this is coming out in court, because I follow the statistics very closely on the Alberta website about COVID hospitalizations. And it seems to me that the number of people who have double and triple doses are the highest number of hospitalizations right now. And I'm remembering I'm remembering it. The argument at the time is I feel like the politicians were persuaded that this was a sterilizing immunity, that if you got your double jabs, you could not catch COVID, you could not transmit COVID, you could not get sick from COVID. Is any testimony being put forth in court to sort of challenge some of those preconceptions?
Oh yeah, all of those were even challenged back in the Manitoba case, back last October, but the judge ignored them. The gentleman from Stanford University, who was a signatory to the Great Barrington Declaration, was part of the evidence that was provided to the court in Manitoba. The problem, and people have argued, why didn't the lawyers from the Justice Centre raise up? They did. They did. That's the point. And everybody's ignored that because nobody's gone to the testimony or gone to the court, okay, and found out what, in fact, the Justice Centre had presented. They had presented all of that data. The point of it all being that the judge ignored it. And this is a dereliction of his duty to the law and to the Constitution. There's the problem. And then that's the elephant in the room. Look, Danielle, one of the problems we have in our country right now is that everybody's in denial. Nobody will believe that the system is broken. they think you're exaggerating when you say the system is broken. And I spoke to your assistant before I came on, and my example was a very simple one, and I can give 100 of them. This is the 50th year. I'm in my 50th anniversary from when I first got elected to a legislature in this country. 50 years ago this year. Okay?
Wow.
I've been around politics for 50 years this year. Okay? When you have a Parliament of Canada with all of the parties who are in that Parliament going along with the idea that an MP can break the law and still sit in Parliament, you know you got a problem.
Which MP in particular are you talking about? There's probably a few candidates.
In this case, it's the Prime Minister. He's broken the law 5 times. The Ethics and Conflict of Interest Commissioner has ruled 5 times that the Prime Minister has broken the law. The Prime Minister, by the way, in all that investigations and all 5 of those cases, right, brought his lawyers forward to argue with the Conflict of Interest Commissioner. Nobody, since those conclusions came out over the last 3 or 4 years, have debated the validity of the decisions that the Conflict of Interest Commissioner has come to. Nobody's challenged them. The Prime Minister broke the Conflict of Interest law, not the ethics, the law of Canada 5 times, and he sits in the House of Commons. Okay, why hasn't an MP from any party introduced a motion or resolution to the Parliament saying when a MP has been found guilty of breaking the law by a Conflict of Interest Commissioner or the courts, they cannot serve in Parliament? Why has no MP done that? Why has no party done that? And I've been preaching this now for months on my blog and at speeches and so on, and in interviews like this. And I can't get it, and then it just goes away. Everybody forgets about it.
You know, I think
can't forget about that. That's the fundamental. If you don't have, so what we have is lawbreakers being lawmakers.
And this is, I guess, the frustration that a lot of regular citizens have, is that there doesn't seem to be any kind of institutional check that exists anymore. You used to have the opposition party be the check on the federal government. You used to be able to have the provinces be the check. You used to have the Senate be the check. You used to have the judiciary be the check. You used to have the media be the check. It feels like all of our institutions have failed.
Exactly. But outside of somebody else being a check on me, I should be a check on myself. So the Parliament should be a check on themselves and pass. They have a conflict of interest piece of legislation. It's only a matter for a minor amendment that could be done in one day in the Parliament of Canada, go for first, second, and third reading in one day, saying, henceforth, no MP that has been found guilty of breaking the law can serve in this institution. Right?
Fair enough. I guess the question would be, is even if you did remove the top person, does that change any of the decision making? I mean,
not the top person. I'm saying any MP who broke the law.
Yes. I guess what I'm concerned about is, are we going to end up with just having a new replacement that's going to continue to violate the Charter of Rights and Freedoms?
I couldn't agree more. I couldn't agree more. Until we reform our political party system, I think we're still in trouble. It doesn't make any difference who wins the next election unless the parties themselves reform. By the way, the other thing that I have suggested is that every political party in Canada, including the one that you're running the leadership for now, is publish every year audited financial statements of the party. No party does that in Canada today, provincially or federally.
I've heard that you've advocated for that. Tell me why you think that's so important.
Well, because if we're going to elect people who are going to manage billions of our tax money, shouldn't we know how they manage millions of our membership money?
And what do you think we would find there? What are you worried about?
Well, I'm not looking to find anything. I'm just looking for all of the political parties to show, because they're public political parties,
right,
that how they run their business, how they run their party.
You know, now that you mention it, I don't think I've ever seen the financials of the UCP. So I don't know how much money they raise each year, and I don't actually know how they spend it.
Well, exactly. But shouldn't there be an audited financial statement of every political party so we know from the start. Wow, they are really trying to manage our money. And these are people I'd like to put in government, because now I have some idea of how they manage my tax money when I know how they manage my membership money.
Okay, I'm going to go on a mission. I'm going to see if I can find those financials, and then I'll get back to you on that. So let's go back.
I think I'm the only party leadership candidate in the history of Canada. I stand to be corrected, but when I ran my leadership campaign in 1979, after it was over and I won, several weeks later, I produced the audited financial statements of my leadership campaign. How much money I raised, how much money I spent, how I spent it. And as a matter of fact, interestingly enough, I had a surplus.
Good for you. That doesn't happen all the time.
And I gave it to the party that didn't do audited financial statement.
Well, you'll be happy to know that we actually have rules in place in our leadership contest where we have to disclose exactly as you describe where the money comes from, where it's being spent, and if there is any money left over, it has to go back to the party. So you were an early pioneer. I think they finally have at least enacted that in law in Alberta. I don't know if it exists elsewhere.
Yes, I know. I noticed that because I looked up some of the legislation a few weeks ago, and I noticed that Alberta was doing that. Kudos to Alberta.
Well, and kudos to you for taking the lead on that. Now, I want to make sure that we don't miss the second point, because I think you very clearly identified why it is the first part of your case, that this is the inappropriate law under the Aeronautics Act to enact these vaccine restrictions. But the second part was the violation of the Charter of Rights and Freedoms. And I know I interviewed you before for the Fraser Forum, but you were very precise in explaining why it was such a violation of the Charter of Rights and Freedoms. And I just want to make sure that people know what your argument is. I've got the charter in front of me, and I kept wanting to jump to Section 6, and you said no. First of all, let's look at how the Canadian Charter of Rights and Freedoms is framed. And there were two things in particular that you wanted to point out to me, and I just want to give you a chance to point those out again. So in the first case, the charter starts with, whereas Canada is founded upon principles that recognize the supremacy of God and the rule of law. Why is it structured that way? Why is that such an important statement in framing out the challenge that you're putting forward?
When the charter was being debated over 17 months back in 1980-81, it was clear to all of us, really, that we, and it was automatic. It was really automatic, Danielle, because you will understand that we all, First Ministers at the time, were raised in a Judeo-Christian society. Right? I came up, my father was in the United Church of Canada. We all went to church to the United Church of Canada. Right from the time I was born until I was about 18 years old, I went to Sunday school and I went to church every Sunday, once every Sunday for sure, sometimes twice, but we had to go at least once. And then we had, Bible school and so on, and Sunday school. Okay, so we all came up in that. So, and looking at the American Constitution, right, which was the one that sort of is the example for the world, really. Of course, it was obvious, inalienable rights, right, came from God, right? There was natural law as well as man-made law. And so when we were carving out a Charter of Rights and Freedoms, it had to begin, in our understanding of who we were and where we were going, that we were working under the auspices, under the situation that we were a God, right, fearing, God-loving country. So whereas Canada is founded, so we wanted to make it clear that all of the rest of what was in this charter will be governed under two huge principles. One, the supremacy of God, and the rule of law, because they stand out in any democratic constitution that you want to look at, right?
And may I just say, now that we've become so secular, I think the thing that's been important to me is that when you use that language, what you're saying is these are not rights that government can give or take away. They're inalienable, meaning they are also innate. They are just the condition of man and woman, that just the condition of being human is that you have these rights, and it is up to governments to respect that they're inalienable and that they're innate. Is that the importance of that language?
Absolutely. And I'm going to send to you, when I get off this interview, a speech that was made by a lawyer from Victoria now. He was a lawyer in Ontario and he was a lawyer in the United States, and he was educated in both countries, okay? all the way to his doctorate in law. So this guy knows what he's talking about. I came in touch with him a few months ago, and I persuaded him to do a speech at the conference we had in Victoria 2 weeks ago, the We Unify, Reclaim Canada conference. And he agreed, and he did on 2 or 3 different occasions, gave different speeches. But one of his speeches had to do with the origin, okay, of law, if you will, or the origin. And his wonderful speech goes through this whole process of who we are in the Western world and how we came to have what we have and the origin of our law. And he did separate it out in this way. There's rule of law and there's rule by law. And the rule of law is the rule of natural progression of rights from the creator to man. And then rule by law is what the man, secular man, has produced in the constitutions and laws of the country. And we must fuse those together, and the rule of law supersedes the rule by law. Okay.
I think that's such an important distinction. So I'm glad you got to that one. The second one, though, that you said were vitally important was the language of Section 1 of the Charter as well. Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. And when I read that out to you, you said to me, the most important words of that sentence were demonstrably justified. And so I want you to explain what that meant in the drafter's opinion. What was it supposed to mean?
Even at the time, and of course, 1981, when I was and premier then from 1979, but ever since for the previous decades before that, it was common understanding that when you talked about justify in government policy, and I'm sure you remember this from your previous experience in politics and in the legislature, justify always meant when bureaucrats came up to cabinet with a new proposal, a new piece of legislation, the first question that was asked by the analysts who were analyzing this before it came to cabinet, is this more benefit, right, than cost? Does this improve our situation? And usually some kind of cost benefit analysis was done. So when we were introducing this into the charter, that all of these sacred rights could be overruled, it was in the context of only if you can demonstrably justify that what you're doing has more benefit than cost. That was not done. So the governments of Canada, all 14 of them, have not satisfied Section 1 in order to be able to overrule it.
That's important. Now, so then let's get to Section 6, which says every citizen of Canada has the right to enter, remain in, and leave Canada. And then it goes on to say every citizen of Canada and every person who has the status of a permanent resident of Canada has the right to move in and take up residence in any province and to pursue the gaining of a livelihood in any province. So that sounds like it should be very clear that you cannot prevent people from leaving the country. And yet, that's what we did.
This is one of the problems we have with the Constitution today, that lawyers will not debate me on. They'll usually say yes or no, or they won't even debate me on. I'm not even a lawyer. Right? I wasn't trained a lawyer, thankfully, because now I can see the forest for the trees. One of the problems many lawyers have is they see the trees and they never see the forest. They never see the big picture because they're bound into this technical interpretation of things. Okay, this is one of the biggest problems we have, because courts, I agree that there are situations where a judge in interpreting the Constitution can read it, and the ordinary person, reasonable person, could read it as being a little ambiguous. But there's nothing ambiguous about these sentences. They're clear sentences that any reasonable person could all come to the same conclusion. If you put 100 reasonable people in the room and ask them to interpret this, it's a 99.9% chance that it'll all come up with exactly the same theme. This is what this means. And this is where the courts have overstepped their bounds. They've taken it upon themselves to take very simple phrases, which are easily understandable by everybody, and reinterpret them and rewrite them almost. Instead of taking an ambiguous clause, which everybody would agree is ambiguous and could be interpreted 2 or 3 ways, and then come up with a determination for the society, they have extended that kind of license to get into wording where there is no ambiguity. Now, that I've never explained that before as well as I just explained it in my own head, at least. Right? I never explained it that well. I'm going to do a blog on that when I get off this, because I just explained it really properly. This is where, and I'm so glad you pushed me on these points, because it forces me to articulate a little bit better than I otherwise would. This is where the essence of our problem comes today. The judiciary, if you wanted to give them deference and try to explain why they're doing things, they have taken ambiguity and make it clear by extending that to phrases in the Constitution which are clear, and then not reinterpreting it, but rewriting that particular thing. That's where our problem lies today.
Completely. So let me ask you this, because I know that they're going to continue fighting you on these points. I'm sure that the government is going to come back and say, oh, you're free to leave the country. All you have to do is get vaccinated. You're free to return to the country without quarantine. All you have to do is get double and maybe in the future triple jab. Why is that not appropriate to say that? Why is that an
because
abuse?
It violates my basic freedoms as an individual, as articulated in the Charter of Rights and Freedoms. There are no conditions in here, and where there are conditions, they haven't met them.
Right. If there were conditions, it would be enumerated in that section of the charter.
Exactly. And even Section 1, as I said, they didn't satisfy being able to override and bring in a travel mandate because they didn't demonstrably justify it. Nor did they do it under the Emergency Act. Nor did any of the provinces do it. Where are the studies? There are no studies. And all the governments did was accept a particular science data, which was at the time already being challenged by other science data. Well, you would think that any reasonable person, let alone a judge, knowing that there was other data available, would look at all the data before articulating a position which was going to be so impactful on so many people. People are dying today. People are injured today. People are having problems today because of what's still in vogue in this country. I mean, this is amazing. And to think that the media are just ignoring that, and even ignoring the testimony of the top epidemiologist who's going against their own government.
Well, I must tell you, like, the headlines all give the impression that the restrictions are gone. So if I'm still thinking through what you have said, number one, it's suspended, not canceled. Number two,
it doesn't apply to everybody.
Doesn't apply to truckers. So our truckers who are fighting this fight on our behalf are still going to be the ones who are not able to travel.
And it doesn't apply to unvaccinated coming back into Canada.
Doesn't apply. So if you're unvaccinated coming back into Canada, you still have to test and quarantine?
Yes.
And so you can get on a plane and go see family members across the country and like go to Kelowna or go to Nova Scotia, but you cannot get onto a plane and go to any other country.
No, because if you do, you got a problem coming back and your freedoms are once again being violated.
So what actually changed this week? I guess
only that we can travel within our own country. Thank you very much for allowing us, like every other country in the world except North Korea and China, to be able to travel in our own country. Thank you. When hundreds of countries have been in that kind of circumstance long before now.
That's so frustrating. Okay, could they make the argument that this is an American restriction on us, that it's the Americans who are demanding that we have this? No, why not?
No, they can't, because if I want to go to England tomorrow, right, or even to America tomorrow, it's the Canadian law that applies when I come back.
So you can get on a plane to leave, but you'd have to have your boarding pass that approve that and your proof of vaccination in order to get the ArriveCan app for them to be able to issue your boarding passes to be able to return.
Exactly.
What about driving across the border? Are unvaccinated people allowed to do that now?
I think they're allowed to go across, but then coming back, they'd still have to do the same thing.
This is outrageous. Like, why is it even being depicted as a relaxation of the rules? It isn't really.
I just wrote an email to a press person this morning who I happen to know, and read the article that person had written, and it said removed. High headline: Canada removes all travel. Right? Removes, right, all travel. And I went back and I said no, suspends their mandate. You have to change the wording. It's suspending the mandate. It's not canceling the mandate. It's not removing it. It's temporarily removing it or suspending it. You're using the wrong wording, because by saying remove, it means permanent. You must say it's suspended. And
So maybe I need your advice on what we need to do next, because I just released a policy yesterday saying we would have an Alberta Sovereignty Act that would allow for us to say we will not enforce federal legislation that violates our areas of provincial jurisdiction. What is a province supposed to do when the federal government is clearly breaking the charter rules and violating the rights of all Albertans? How can we get our citizens protected? How can we make sure that our citizens have free mobility? How can we make sure our nothing?
You cannot. You're going to have to fight what I'm doing, the charter, because the charter applies to all of Canada, and therefore we're going to have to fight it through the charter rights. That's why I've been so adamant about it. There's no other piece of constitution or law like the Charter of Rights and Freedoms, like our Constitution, because it applies to everybody. You'll always get into an argument when you. It's a good tactic in the sense of highlighting the problem we have in our country vis-a-vis federal jurisdiction of the provinces, and so I commend you for that. But at the end of the day, the federal law is likely to prevail over the provincial law.
My goodness,
in this kind of a battle. But it helps to highlight the issue, and that's what needs to be done. But if everybody would get on the battle of arguing that our charter rights are being violated, and these charter rights are universal in Canada, they apply to everybody, then I think that's our best chance. By the way, you started off by talking about, or you might have been your assistant too, my court case. We also believe, and you might be interested in that, we also believe that part of the reason why the federal government did suspend some of these mandates is because of court cases like ours.
Oh, good.
We believe that because we were, in the last 5 or 6 days before the mandates got lifted, we were moving towards where we got with that top epidemiologist. And we were also asking, by the way, to cross-examine other bureaucrats in the system who at a very high level, that if they too were allowed to testify, and I don't know why the judge will not grant that request, was still outstanding. Hopefully the judge will rule out in the next few days. I'll find out quite likely from my lawyers today. We believe that there are people in the bureaucracy at the highest levels, which we now know to be true. The top epidemiologist from the Public Health Agency of Canada has said we never recommended it. The top policy person from Transport Canada did. And we think there are others who the federal government would not want to see put on the stand and cross-examined by our lawyers, because they're quite likely either to make a mistake or to do as these two have already done, say, we never recommended it. We can't find the science to justify this. Apparently, the epidemiologist actually said there's no science to be able to put in these travel mandates under oath. And so we believe that the movement that we have been making in our case over the last couple of weeks, which anybody listening and watching and hearing, which the federal government does every day, get reports on what happened in the court case, because it's right up against their Aeronautics Act, that they were worried, and therefore by doing what they did, that would perhaps give the federal Justice Department a reason to ask to quash our case against them, because now we have, taken away some of the mandate or suspended some of the mandate. And of course, it's going to backfire, because I was called by my lawyers and asked if in fact this comes about, do you still want to proceed ahead? And I laughed. And the lawyer had to say to me, I understand, Mr. Peckford, why you're laughing, but under law, And in this client-lawyer relationship, I need an answer, and a laugh is not an answer. So you have to tell me specifically the words. And so I said, I'm sorry. Full steam ahead.
It's funny. I was going to ask you that same question to start our interview. Is it all for naught? Have you won? Are you dropping your case? I'm glad I didn't get you laughing at me at the beginning, because I can now see from our conversation why you've got to keep it going. So tell me what you need, because when I was with the Alberta Enterprise Group, one of the things that our organization did is we intervened in the Bill C-69 case. So you actually can have other parties that say, hey, me too, we think that this is a violation. Do you have other interveners in your case? Are you looking for other interveners in your case?
Well, the case is underway right now, and it's too late for interveners.
Is it? Okay.
We have to do it at the beginning. So we're well along. I mean, we're almost now at the end of the cross-examination of all of the evidence from both parties, okay? And then there will be a pause, and then the hearing publicly will begin on September the 19th for 5 days. That's already been determined. So this case will be debated, argued, and heard publicly and finished at the 5 days after the 19th of September, the 24th of September. And then the judge goes away and then makes a decision. So we're well along in our case right now. And all we need right now, and all I need, and the Justice Center need, is to make sure we have sufficient financial support behind us. Because as you know, the Justice Center just depends upon donations from individuals across the country. And so you can go into the Justice Center website, jccf.ca, and you can punch on support, and then you can click on donate, and then you can click on select a campaign, and my campaign will be there among many others. So anybody who wants to support, and remember, you understand this, the deal was that when I agreed to do this, I had to sign off that at the end of the day, if we go all the way to the Supreme Court of Canada, and there's a difference in how much was raised and how much it costs, I have to bear that cost.
Do we know how much more money you need? We want to make sure
we
can
will
get
never know until it's all over, because we don't know how far this is going to go. So we don't know what the end price will be. All I do know is because we also hired outside lawyers. The JCCF did. Mr. Keith Wilson, the lead lawyer, is outside. He's not with JCCF. And therefore, of course, he has to recoup his costs. And so, besides JCCF themselves, who have two other lawyers full-time on this with my outside lawyer, right? With the JCF's outside lawyer. So, and this has gone on for months and months and continues to go on for months and months. It's going to be an expensive proposition. So I say to people, if they're really, really interested, the best way they can help me and the case, right, going forward, because it may go on for another year yet, because it'll quite likely get appealed to the Supreme Court of Canada. So,
and that's a tactic of government, that they like to drag things out so that they can bankrupt the people going against them.
Once again, you'll enjoy this. We started off with 5 lawyers from the federal government. There's now 11.
Oh gosh.
We started off, they were going to have 6 or 7 expert witnesses. It's now 16. So as we got into this case and the federal government got seized with it, they realized they might have to beef up how many lawyers they got arguing this case. We might have to beef up the number of expert witnesses we have to beef up this case. So there's a really good example that this has been taken very seriously. To go to 5 to 11 lawyers, to go from 7 or 8 expert witnesses to 16. What else can you read into that other than this federal government knows they have a case on their hands?
Well, and you've also made me even more anxious, because I thought we were winning on the freedom front, because we've seen all of the provinces relent on their restrictions. We see that you're making some success, but the fact that they're fighting it so hard just leads me to believe they want to keep this architecture in place so that they can invoke it anytime we get a new virus or a new variant. And that's what we've got to defeat.
Exactly. And that's the other reason why freedom fighters who contact me every day and all these various organizations across the country have to be very, very careful in their behavior. In other words, continue to do civil disobedience, but do it in a manner whereby the federal government can't divide and conquer and say, you guys are trying to destroy the country, that you are terrorists, that you are somehow financed by outside forces and all that kind of stuff. So our phraseology, even our words, our very words and sentences in all these freedom-loving organizations who are on our side have to be sure that they proceed in a manner which does not allow the federal government and those against us to use this as another reason why they have to impose more stuff later on. Because look what we're dealing with. We're dealing with racists. We're, like the Prime Minister called me a racist, called everybody who's on and vaccinated a racist, right? Misogynist, right? Taking up space perhaps that you shouldn't be taking up in this country. By the way, we've repeated these words in our lawsuit. This is actually before the court, these words. We have quoted the Prime Minister's words in our lawsuit. And so,
good.
So the point of it all being that what everybody can do besides financially support cases like mine through the Justice Center and other law firms or whatever is to ensure that as they argue our case, we do it in a rational way because we have rationality and science on our side. We don't need to go down the road of particular procedures which are questionable. We don't need to do that. We have law, logic, and science on our side.
Give me some political advice, if you would, because as I mentioned, I see that in the U.S. that Florida, South Dakota, other states have been able to chart a separate course. How can we chart a separate course in Alberta if it is the case that the federal government tries to bring through a reinstatement of these?
The best way a province can do it is to properly follow the science and follow the law. And that's where a province, if you could get 2 or 3 provinces to say, we will never bring in these mandates anymore because this is anti-constitution, anti-charter, anti-science, right? We will do things like they did in Sweden. We'll do things like they did in India, and more closer to home, we'll do things like Ron DeSantis did, and we'll do things like South Dakota did and the other 18 or 19 states, okay? One of the really interesting lessons coming out of all of this, forgetting Sweden and India and other countries, but in federations like the United States and Canada, here's a very interesting thing, is that DeSantis, being a lawyer, Yale trained, Harvard trained, very bright fellow, and fundamentally an originalist, interpret the Constitution as written. If we want to do it differently, change the Constitution, and there's a formula for doing it, as there is in Canada. And the same way with the lady in South Dakota. They went back to the Constitution and the Federalist Papers, and they determined that very often we have more powers as a state than we think we have. And DeSantis was willing to exercise that. I was, when I was Premier, if you remember, I went to the Supreme Court of Canada 3 times to exercise provincial rights, as did Lougheed years ago, right? Took on the federal government. And this is where the provinces have been very deficient. They have allowed the federal government to come into areas of provincial jurisdiction, allowed them, and therefore diminish their argument as related to the division of powers. Okay? And so there's the problem. There's the problem. If there were 2 or 3 provinces that didn't go along with these mandates and did something like DeSantis did and hired public health people like the new black person who is the public health officer now for who came out of the frontline doctors who
in Florida,
right? He's a hero to anybody who looks at constitutions these days and looks at health and good research, right? So DeSantis not only did that, but he brought in people who were more open-minded, right? And that's how he fought it. So it can be done. So no provincial premier has done what American governor has done. And we always thought, Daniel, you and me and all of us, especially years ago, always thought premiers had more powers than governors. Well, just 1 second now. There are in certain areas where that's true, but there are other areas where if it's unclear who has jurisdiction, it goes to the states, not to the federal government. In our case, it goes to the federal government, provinces.
That actually explains so much. But it's interesting to me you say you need 2 or 3 to do it. You don't think I always felt like Alberta, if we just charted the path and freedom, followed the focus protection model that we've seen in some of the red states that others would follow, do you think it's important to have strength in numbers? Do we need to get Saskatchewan and Ontario on side with us?
You need
And
to
why
get one
is
in the
that?
west and one in the east.
Really?
If you want good political advice, you need to
Yeah.
get somebody in the east to break, right? And to do, not break, do what's right, follow the law, follow the Constitution, follow the Charter, and follow science. Bring in more other people. One of the things I did when I was first minister of municipal affairs, my first portfolio, my first question was, the deputy minister came and he said A, B, and C. I said, is that true? Well, he said, I'm explaining it. Well, I said, is that really true, though? And he said, well, what do you suggest, Minister? Well, I said, I'd like to get somebody from outside. He said, we really don't need to get. When he came back and said to me, well, you don't really need to get somebody from outside, that convinced me we did.
Absolutely.
And from that day forward, I always questioned the bureaucracy, tried to hire people who fought with me rationally, who argue with me rationally. And the more of those people you have around you who are sensible but are arguing the point, and at the end of the day will accept your final conclusion, but only after they've gone through the argument and given you an opportunity to have something from outside. That's what you need to do.
One last thing then, if they aren't getting health advice from within their own departments, I guess we have to begin asking the question of why are they making the decisions that they're making? Is there any way you can call Justin Trudeau to testify about where, if he's not getting advice from the public health agency, where is he getting it from? Why is he doing this if there isn't a foundation of science behind it?
Exactly. And that's a really good question. I don't know if I don't know if executive privilege comes into play here, and the courts would allow it to happen. I do know what I'm talking about when I say, people might say, I just said that off the top of my head. I say very little off the top of my head, even though people think I say a lot of stuff off the top of my head. Guess what? There was a time when I was premier when I was asked to support a former premier's argument of executive privilege before the courts of Canada. So I know what I'm talking about.
Right.
And
so we're not going to be able to hold him to account. We probably do.
It might get to be too much political theater and be counterproductive at the end. So the key that the lawyers will always tell you, who are good lawyers, and you argue with them and fight with them, and at the end of the day came to them, you've got to, and this is one thing a lot of lawyers have said about our case, unlike some of the other cases, it's extremely focused, right? Because once you start to get into secondary issues, even though they bear on the primary issue, the judge tends not to be, right? You're putting the judge off into it, and they might then have an opportunity to argue against you on that secondary thing, right? And eliminate the case.
I totally get your point. You know what I think? What I'm hearing, though, is that people want to have a full and thoughtful discussion about why politicians made the decisions they made. And as you say, I mean, in the court, it doesn't get necessarily the public hearing. When we do public inquiries, often a lot of that is done behind the scenes. I've kind of wanted to see some kind of a congressional style hearing where different parties come forward, sort of like what we're watching with the justification of the Emergencies Act. Let's just get these hearings going to understand why politicians made the decisions they made.
That's why I, in my speech, which I called a new Magna Carta for Canada, on the steps of the legislature, I'll send you, I don't know if I sent you a copy or not. I thought I did. I thought I had forgotten to send you a copy, and then I did send you one.
I'll look it up. Anyway, Laura will have it if that's the case. I'll make sure we dig that up.
Yeah, just check your thing, but I'll send it again. I called for a Magna Carta, a new Magna Carta, and the first item in that was a national inquiry led by citizens, which examines what was necessary. Now, it's a national, not a federal inquiry, not a provincial inquiry, a national inquiry, which therefore will examine all the mandates of all the 14 governments and determine what was necessary and determine what was constitutional and what wasn't. And whoever is responsible for breaking any laws that this inquiry finds will have to be accountable before the law.
You know what?
taken
We
to
should
court.
get that inquiry started. That citizen discussion started in Alberta if the federal government doesn't act on it. So I may be calling you if I'm successful in October. I know Lieutenant David Redmond has also been an ally in fighting the same fight. There's some really good folks
He-
who've been in government before who I think would be
If
great to
you
lead
if
it.
you get elected, the first call you should make is to David Redmond.
I've already put him on notice that I will be calling him, and you'll be my second call. And thank you so much for the work that you're doing. We're going to keep a close eye on what happens September 19th to 24th. I sure appreciate everything that you're doing. I want to remind people to donate to the cause at www.jccf.ca, and you can choose the campaign so that that Mr. Peckford doesn't end up being short on this, because it's such an important fight to. And good luck to you. We sure hope you win it.
Thank you, and all the best to you in your fight.
You bet. Thank you for that. All right, Brian Peckford, as I mentioned, he was the Newfoundland premier from 1979 to 1989. We walked through a little bit about what the intention of the drafters was in writing the Charter of Rights and Freedoms and the framing of it in particular. And as you can see, what a great frustration. I thought that last point that he made there was a really important one, because I had also been of the view that provinces were more powerful than U.S. states. But look at that residual power argument, that if it's not particularly enumerated in the Constitution, in the US, the power falls to the state. We've got the deference going the other way, where it's not particularly enumerated. The power runs to the federal government. You know, my friends, if you've watched me speak, you know that I have talked about how we have a constitutional reckoning coming, that not only is the federal government not abiding what is written in the Constitution, but they're taking liberties and pushing it, I think, far beyond what it is that citizens of Alberta want to see. We also know that as we go forward, becoming the second largest economy, becoming the second most populous province, which I've seen is potentially to happen by 2050, we can't continue to operate under the rules that we have that are so clearly stacked against our province. So I thought that would give you a little bit more of a background in what some of the thinking was at the time back in 1982. We'll have to keep our eyes peeled to that testimony, because what happens in September is that's also normally the start of a new respiratory virus season. So we're going to be severely tested. It's pretty clear to me, based on that conversation, that the federal government just can't quit these regs. They just can't quit these rules. And so that means that we're going to have to be that strong counterbalance. I'm hoping that Saskatchewan joins us. I'm hoping now that Ontario has a mandate that we can convince them to go down a different track, because it sounds like it's going to take that kind of collective effort to push us back in the right direction. Don't worry, my friends. I'll be standing up fighting for you, because, as you know, I'll always put Alberta first. I'm Danielle Smith. Welcome to this new edition of the Danielle Smith Show. We'll continue it again next week.